A very good evening to everyone who have joined us today to be a part of this academic initiative. I am Sankirtana and I will be your moderator for today. I take immense pleasure in welcoming all the esteemed members of the KSBC Law Academy, distinguished advocates and lawyers, academic scholars, students, and everyone else who have joined us this evening to be a part of the Imperative Lecture Series. Today is the third day of the week-long lecture series. We request all the participants to remain on mute throughout the duration of the session, kindly requesting all the participants to send across any questions that you have on the chat box. After the lecture is over, some of the selected questions will be posed to our esteemed speaker by our panelists. Please utilize this opportunity. Now the forum is open to our esteemed speaker. Thank you.
Thank you very much.
Thank you, sir.
I welcome all of you to the third day of this session on Bharatiya Nagarik Suraksha Sanhita. Yesterday we have covered up to section 173 of BNSS, which is equivalent to section 154 of the Criminal Procedure Code. That is, what should happen or what would happen if an information relating to a cognizable offense is given to a police officer, how it will be dealt with, and if the police officer refuses to receive, what steps will have to be taken. And if the superintendent of police also does not take any action, what is the next step to be taken? All those things we have discussed yesterday. Now we are moving on to section 174 BNSS, which equivalent is section. How can I increase my volume, madam? Hello?
You're fine.
Somebody has put in that I have to increase the volume. How to increase it?
No, sir, you're audible. It's their problem. Please continue.
Okay. Thank you. Now we will move on to section 174 BNSS, which is equivalent to section 155 of the Code of Criminal Procedure. When an offense is committed against a person, a common man or a layman, who doesn't have the knowledge of law, he will not be in a position to know whether the offense committed against him is a cognizable offense or a non-cognizable offense. What all he knows is that some offense has been committed against him, and therefore he must go to the police station and seek redressal. That is all what he will be knowing. So he will automatically go to the police station and give information to the police regarding the commission of an offense against him. The police, on receiving that information, come to know that it is not a cognizable offense, but it is a non-cognizable offense. As already discussed earlier, that in case of a non-cognizable offense, the police have no power to register the case. Police have no power to investigate into the matter. Police have no power to arrest the accused. Then what the police should do? That is what is provided in section 174 of the BNSS, which equivalent is section 155 of the CRPC. Subsection 1 of the said section says, when an information is given to a police officer in respect of a commission of a non-cognizable offense, then the police officer will have to reduce that information into a separate register prescribed for the said purpose. Since he cannot register the case, since he cannot investigate, since he cannot arrest the person, the only remedy or option open to the police officer is to direct that informant or the victim to go to the magistrate by saying that he cannot investigate into the matter because it is a non-cognizable offense. Therefore, he must go to the magistrate court and inform the court. And if the court were to direct him, then he would be able to investigate. That is one thing. Up to this, there is no amendment, there is no change. What is found in section 155 CRPC has been reproduced in the form of section 174 of the BNSS. But there is one addition that has been made in BNSS. That is, when such company information relating to a non-cognizable offense is received in the police station, and the police station records the gist of that information in the register, it is expected of the station house officer or the police officer who is in charge to submit the daily reports to the magistrate, informing about the number of such cases registered in sense entered in the police station. This is an addition that has been made by way of subclause 2 to subsection 1 of section 174 of BNSS, which is not found in CRPC. Except that there is no amendment to section 155 of the CRPC, whatever is there in second CRPC has been brought as it is in the form of section 174 in BNSS. Anyway, for the benefit of our youngsters and freshers, I feel it is my duty to complete my discussion on section 155 so that it will give them the complete information as to how to go about in respect of a non-cognizable offense. So when a person informs the magistrate about the commission of a non-cognizable offense, then the magistrate will order the police officer to investigate into it. So when an order is passed by a magistrate directing the police to investigate into a non-cognizable offense, then the police officer will get power to investigate that non-cognizable offense also, of which he was not otherwise entitled to investigate. The law further says, section 174, that is 155 CRPC, that the police officer to whom such power is entrusted by the magistrate will have all the powers of a police officer investigating into a cognizable offense, except that he cannot arrest the accused in case of a non-cognizable offense. This is another subsection in section 174 BNSS, which is found in section 155 CRPC also. There may be a situation where the information given by the accused, given by the informant in respect of an incident, if read, it gives rise for more than one offense. It could be 3 offenses, 4 offenses. It could be more than one. So when there is an information given to when the information contains offenses of more than one, and if any one of them is cognizable and others are non-cognizable, for example, let us say that an incident that has taken place has resulted in such a situation that 4 sections of the Indian Penal Code are attracted. Of those 4 sections, let us say only 1 section is cognizable and remaining 3 sections are non-cognizable. Then what is the situation? Should it be treated as non-cognizable or cognizable? Section 174 subsection 3 says, equivalent section 155 of the CRPC says that in such a situation, even though there is only 1 section which is a cognizable offense, the police officer can treat the entire information as a cognizable one and take it, consider it as a cognizable offense, and proceed under section 173 BNSS, that is section 154, and register the case and prepare an FIR, submit the FIR to the court. This is what section 174 BNSS, which is equivalent to section 155 CRPC, says in respect of non-cognizable offense. Then coming to section 156 CRPC, its equivalent is section 175. Police officers' power to investigate a cognizable offense. This section has 4 subsections. Subsection 1 says, any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable offense which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or by under the provisions of Chapter 14. It means that if the case that is registered is in respect of a cognizable offense, the police officer has got power to investigate into that offense even without an order from anybody, including the magistrate. So the police have got complete power to investigate into a cognizable offense without waiting for any orders. A proviso has been now added to Section 175 BNSS, which was not there in Section 156 of the corresponding Section 156 of the CRPC. What is that proviso? Provided that considering the nature and gravity of the offense, the superintendent of police may require the deputy superintendent of police to investigate into the case. Considering the nature and gravity of the offense, once we say a cognizable offense, yesterday itself I told, I believe, that right from a smallest of the small offense, that is Section 159 of the IPC, affray, which is punishable with just 1 month of imprisonment or 1,000 rupees fine, up to death sentence, all are cognizable offenses. There are number of cognizable offenses in between of varying terms of punishment prescribed, right from 1 month to death sentence. So therefore, this proviso says that having regard to the nature and gravity of the offense, of the cognizable offense about which information has been given, if the superintendent of police is of the view that it has to be investigated by a police officer of a higher rank, then such investigation can be given to the deputy superintendent of police to investigate into the matter. And such direction will have to be given by the superintendent of police. That is another proviso which has been added to Section 175, which was not there earlier in Section 156. Then there is one more addition to Section 175. When we discussed on Section 173 yesterday, that is information regarding cognizable offense, we discussed about a particular point regarding supposing a person goes to the police station and give information relating to a cognizable offense. Police officer refuses to register it. Then he sends that information, which is in writing by RPID, to SP. Under law, SP is directed to investigate into the matter, or he can entrust that matter to any of the subordinate officers to investigate. Even that is not done. Under such circumstances, the aggrieved person, that is the person who is aggrieved, can come to the magistrate court and make an application under Section 173, subsection 4. That I told yesterday. That particular provision should not be mistaken with a private complaint. Private complaint is altogether different. This is an application that is given to a magistrate along with an affidavit, wherein it is averred about the information given by the informant to the police and refusal by the police to register, and about the information sent to the SP by through RPID, and SP also has not taken any action. Therefore, a request will be made to the magistrate to direct the police to register the case and investigate. That is what has been now added by way of subsection 3 to Section 175, which was not found in Section 156 of the CRPC. What does it say? Any magistrate empowered under Section 210. 210 is a section which deals with cognizance. About that we will discuss later. Any magistrate empowered under Section 210 may, after considering the application supported by an affidavit made under subsection 4 of Section 173, and after making such inquiry as he deems things necessary, and submission made in this regard by the police officer, order such an investigation as above mentioned. What does it mean? So when an application under subsection 4 of Section 173 is made before the magistrate, such application should be accompanied by an affidavit. Here, perhaps this is the only section, to the best of my knowledge, where it is stated an application should be accompanied by an affidavit. We know that in civil law, The civil rules of practice will clearly say that every application shall be accompanied by an affidavit of the party. But in criminal rules of practice, such a provision is not there. So mere filing of an application under a particular provision would be sufficient. But so far as the application under section 173 subsection 4 is concerned, this amended provision subsection 3 of section 175 clearly says that such an application shall be accompanied by an affidavit. Because in the affidavit, the aggrieved persons must swear to the fact that he has gone to the police station, he gave an information relating to a cognizable offense, and the police officer's rejection to register the case must be sworn to. And it should also be sworn to by the party that he has made all efforts to knock the door of the superintendent of police, and even that also failed. And therefore, he is before the court, requesting the court to direct the police to register the case. All these things are to be averred in the affidavit to be filed along with the application under section 173 subsection 4 of BNSS. So once such an application is filed, the magistrate will have to inquire into it. And if necessary, he must get the police officer and also inquire with him. And then direct the police to investigate into the matter in respect of the information given by the informant. This is what the new section, subsection 3 of section 175 BNSS, of which the equivalent is section 156 CRPC, states. Then there is one more addition made in BNSS to the same section 175, which was not found in its equivalent section 156 in CRPC. What is it? It is subsection 4. Subsection 4 says, any magistrate empowered under section 210. 210 is equal to section 190 of the Criminal Procedure Code. Any magistrate empowered under section 210 may, upon receiving a complaint against a public servant arising in the course of discharge of his official duties, order investigation subject to A. Receiving a report containing facts and circumstances of the incident from the officer superior to him. B. After consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. What does it mean? Supposing a complaint is filed against a public servant in respect of the act which he has committed in the course of discharge of his duties. So it is alleged that the public servant has committed an offense, punishable under a particular section of the Indian Penal Code. Now, what the magistrate is required to do? This is a new subsection that has been added. According to this new subsection, when such a complaint is filed before the magistrate against a public servant in respect of an act said to have been committed by him in discharge of his lawful duty, has to follow two things. Number one, he must receive a report containing all facts and circumstances of the incident in question from the officer superior to the officer against whom the case is filed. Supposing the case is filed against a tahsildar or against a taluka executive magistrate or against any such officer, a report will have to be obtained from an officer superior to him. Example, if it is a tahsildar, from this assistant commissioner or a subdivisional magistrate, so a report will have to be received regarding the particular incident in question. Secondly, after consideration of the assertions made by the public servant as to the situation that led to the incident, so a public servant also has a right to submit to the magistrate as to under what circumstances or compelling situations he was forced to that incident has occurred, that he has forced to Allah, that incident has occurred. So that report also should be taken, and after considering both the reports, then the magistrate should take a decision in this matter. This is what subsection 4 says. It is in a way a protection to a public servant who is discharging his lawful duties, and during the course of that discharge, If any offense according to the complainant has taken place, said to have been committed by him, then these are the steps that are to be followed by the magistrate as contemplated under clause A and B of subsection 4 of section 175 BNSS. Then, coming to section 157, procedure for investigation. This is equivalent to section 157 of the Criminal Procedure Code. What does it say? If from information received or otherwise an officer in charge of a police station has reason to suspect the commission of an offence, which he is empowered under section 175 to investigate, he shall forthwith send a report to the same to the magistrate empowered to take cognizance of such offence upon a police report and shall proceed in person or depute one of his subordinate to this part. What does this section says? The importance of this section is whenever an information relating to a cognizable offence is given to a police officer, or whenever the magistrate directs the police officer to investigate into the incident, then it shall be the duty of the investigating officer either to go by himself to the spot or depute any one of his subordinate. But this section further emphasizes that before going to the spot, he must ensure that the information in original form reaches the magistrate. This is a very, very important provision that every one of us, an advocate practicing on criminal side and a judicial officer presiding over a criminal court, must be aware of, according to me. Because the law envisages that it is the duty of the investigating officer that before proceeding to investigate, before proceeding to spot, he must ensure that the first information report is dispatched from the police station and sent to the magistrate. Original first information should not be in the police station. It must be dispatched immediately and it must reach the magistrate. That should be assured. The investigating officer must get himself assured of that particular fact before proceeding to the spot. So this is a very, very important aspect because whenever we are considering the aspect of delay in FIR, two things will come before us. One is delay in lodging the complaint, delay in giving information to the police, number one. Number two, delay in transmitting the FIR from the police station to the magistrate. Both the delays are really goes against the prosecution unless there is proper explanation given for the delay so caused. So if that explanation is not given, the accused can always take the benefit of that, though that alone is not a ground for acquittal. Therefore, this aspect will have to be seriously taken note of, and the timings as contemplated in the section are very important. If there is a delay in giving the information to the police, that has to be accounted by the police investigating officer. If there is a delay in transmitting the FIR from the police station to the court, even that delay will have to be explained. It is in this context that section 157 CRPC, that is 176 BNSS, has been incorporated. In this section 176, there is one proviso which has been added. One proviso where addition has been made and one proviso which has been newly added. What is it? In the second proviso to subsection 1 of section 176, that is procedure for investigation, it is stated in CRPC, it was like this, provided further that in relation to an offense of rape, the recording of statement of the victim shall be conducted at the residence of the victim or in the place of her choice, and as far as practicable by a woman police officer in the presence of her parents or guardian or near relatives or social worker of the locality. This was there in CRPC and the same is there in BNSS also. And the further words which have been added now to the same proviso is that, and such statement may also be recorded through any audio, video, electronic means, including mobile phone. So that can be electronically recorded. That is what has been added to the second proviso to subsection 1 of section 176, which deals with procedure of investigation. And in subsection 2 also, there is an addition that has been made, wherein it is stated, in each of the cases mentioned in clause A and clause B of first proviso to subsection 1, the officer in charge of the police station shall state in his report the reasons for not fully complying with the requirements of that subsection or by him. And this is added. This is what is added. Up to that, there is no change. What is found in CRPC is in BNSS also. Thereafter, the last two lines, and forward the daily report fortnightly to the magistrate, and in case mentioned in clause B of the said proviso, the officer shall also forthwith notify to the informant, if any, such manner as may be prescribed by the state government. This is an addition made to subsection 2 of section 176, procedure for investigation. So these are the additional words. So a new provision has been added in the form of proviso 3 to section 176. What does it say? On the receipt of every information relating to the commission of an offence, which is made punishable with for 7 years or more, the officer in charge of a police station shall, from such date as may be notified, within a period of 5 years, by the state government, in this regard, cause the forensic expert to visit the scene of occurrence and collect forensic evidence in the offence, and also cause videography of the process on mobile phone or any other electronic device. What is the meaning of this? According to me, the meaning of this is, in a serious offence means the offence punishable with 7 years and more than 7 years, above 7 years. In all serious offences, the collection of visit by a forensic expert to the scene of occurrence is mandatory, has been made mandatory. So the forensic investigation has to be done in such serious offences. But the lawmakers have taken note of the fact, perhaps, that all the state governments in the country are not fully equipped to meet this challenge. All the laboratories may not be fully equipped to meet the challenge. Therefore, it is stated, once again I am reading that proviso, on the receipt of every information relating to the commission of an offence, which is made punishable for 7 years or more, the officer in charge of the police station shall, from such date as may be notified within a period of 5 years by the state government. I'll stop there. So according to me, the state governments have been given 5 years time from now to see that the forensic laboratories are fully equipped to meet all types of challenges. And thereafter, the state government will have to notify the date from which the facility can be obtained from the forensic laboratories of the respective state governments. I'll read further. Notified with a prescribed period of 5 years, state government cause the forensic expert to visit the crime scene to collect forensic evidence in the offence, and also cause videograph of the process on mobile phone or any other electronic device. So once the forensic science is fully equipped in the state and ready to meet all types of challenges, which should be done within a period of 5 years, it is mandatory for the investigating officer to get a forensic expert to the scene of occurrence and have the place investigated as per the forensic science to collect necessary material, evidence. Then the question may arise. That is, what if such a situation were to occur within 5 years? Supposing a serious offense has taken place, which is punishable with more than 7 years, and forensic evidence is absolutely essential. But in the forensic laboratory situated locally, it may not be fully equipped. Then what should be done? Can the investigation go without forensic science? No, for that a proviso has been added to subsection 4 of section 176. What does it say? Provided that where forensic facility is not available in respect of any such offense, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. So the state government will have to take steps to notify any other laboratory in any other state in the country which is fully equipped and direct the investigating officers, the police officers in the state to take assistance from such laboratories in order to see that investigation includes a forensic investigation also in each and every case on and from 1/7/2024. This, according to me, is the meaning that could be understood from the reading of subsection 3 and proviso to subsection 3 of section 176 of BNSS, the equivalent of which is section 157 CRPC. So far as section 158 and 159 CRPC, which is equivalent of which is 177 and 178, there is no amendment. And so far as section 179 BNSS of its equivalent is 160 CRPC, there is no amendment, major amendment, except adding a proviso that no male person under the age of 15 years or above the age of 60 years or a woman or a mentally or physically disabled person or a person with acute illness shall be required to attend at any place other than the place in which such person resides. That means they must go to the place where these people are residing and the police officer should investigate, because section 179 deals with police officers' power to require attendance of a witness. The police have got power to summon any person as a witness who, according to the police, is acquainted with the facts of the case or whose statement is relevant for the purpose of the case. But if such person is suffering from these infirmities, that is, a male under the age of 15 years or above the age of 60 years, or a woman or a person mentally or physically disabled or a person with acute illness, they cannot be summoned to the police station. The police officer himself should go to the place where those persons are there and record the statement or examine them. And there is a further addition by another proviso, second proviso to subsection 1, provided that if such person is willing to attend at the police station, such person may be permitted to do so. Law has given exemption to them. But if, in spite of there being an exemption, if those persons volunteer to say that we are ready to come to the police station, they can do so. Then section 161 CRPC and the corresponding section in BNSS is section 180. 161 to 63. There is no amendment. There is no change. Then we will move on to section 164 of the CRPC, the equivalent of which is section 183 BNSS, which deals with recording of confessions and statements. Here, there is a small change. Though the change is very small, its effect is great. How? We will see. In CRPC, section 164, subsection 1, it is mentioned, any metropolitan magistrate or judicial magistrate may, whether or not he has jurisdiction in the case, These are the words which are found in subsection 1. These are the words which are found in subsection 1 of section 164. In its place, subsection 1 of section 183 says, any magistrate of the district. So the entire section, that line, any metropolitan magistrate has been abolished. Or judicial magistrate, any judicial magistrate, may whether he has jurisdiction or no jurisdiction, that totally has been removed, and in its place, any magistrate of the district has been added. So if an offense has taken place in, say, for example, Kanakpura, any magistrate in the entire district of Ramanagara is empowered to exercise power and record statement of the witness or record confession of the accused under section 164 of the CRPC, which are equivalent of which is section 183 of the BNSS. This is the only amendment that has been brought in section 183, that is 164, that is section 183 of the BNSS. But of course, in subsection 6 of section 183, that is equivalent to section 164, two provisos have been added. Section 6, subsection 6 contemplates that in case of an offense punishable under section 64 to 71, that is outraging the modesty of a woman, rape, sexual offenses against women and all that, acid attack and all that, the magistrate shall record the statement of the person against whom such offense has been committed in the manner specified in subsection 5, as the commission of the offense is brought to the notice of the police. That is recording of the statement of a victim under section 164 CRPC, and its equivalent is 183. For that, a proviso has been added, provided that such statement shall, as far as practicable, be recorded by a woman magistrate, and in her absence, a male magistrate can record the statement of a victim in the presence of a woman. This is one provision that has been newly added to subsection 6 of section 164. There is one more provision which has been added, provided further, in cases relating to offences punishable with imprisonment for 10 years or more, or with imprisonment for life or with death, the magistrate shall record the statement of the witnesses brought before him by the police. So in all these heinous offences, that is offences which are punishable with an imprisonment for 10 years or more, or with imprisonment for life, or with death, the statement of the witnesses, when brought before him by the police officer, will have to be recorded. This is another new proviso that has been added to subsection 6 of section 183, BNSS, equivalent of which is section 164. And in the fourth proviso, few words have been used, that is recording of a statement through audio, video, electronic means, preferably by mobile phones. So these are the changes which have been brought in section 164, which is found in section 183 of BNSS. Then section 164A CRPC deals with medical examination of the victim of rape. Medical examination of the victim of rape. Here, CRPC did not provide that timeline within which the medical officer who examines the victim of rape has to submit a report. So we have seen in a number of cases where the charge sheet will be filed, submitted, awaiting report from the medical officer. In order to overcome such practice, BNS has added one provision, which is in the form of subsection 6 to section 184, the equivalent of which section is section 164A. As per this newly added provision, the registered medical practitioner shall within a period of 7 days forward the report to the investigating officer, who shall in turn forward it to the magistrate referred in subsection 9 as a part of document referred to in the clause so and so of so and so. So a timeline has been fixed within which the medical officer who examines the victim of rape has to submit the report. So that will take care of that particular problem. This is another change that has been brought out in section 164A CRPC, and its equivalent is section 184 BNSS. Then coming to section 165, that is 165 CRPC, equivalent is section 185 BNSS. The entire section has remained unaltered and it has been reproduced in BNSS, and only addition is in 185 subsection 2, which says that the search and seizure conducted under section 165 CRPC, that is equivalent to 185 BNSS, shall be through audio, video, electronic means, preferably by mobile. So this is a very, very important change that has taken place, because now all those questions which, the stock questions which we were asking, and also the way in which the things were being done, that we used to ask the witness, I was summoned to the police station, I was asked to sign the document, therefore I signed, therefore I do not know the contents of the document. Thereby he was being treated hostile. Now here, when the entire search and seizure, preparation of mahazar has to be videographed through any audio, video, electronic means, and preferably by mobiles, every action will be videographed. Therefore, the police also will have to do their job at this part only in the presence of an independent witness or witnesses, and the witnesses also must sign before the police officer and other witnesses. And this is one another important change that has been brought out by way of proviso to subsection 2 of section 185. Then, in the same section, that is search and seizure, there was no timeline fixed earlier in CRPC within which the search and seizure report has to be submitted to the court. But now, by introducing subsection 5 to section 185 BNSS, it is clearly stated that search and seizure report shall be submitted, the copies of that shall be submitted to the magistrate not later than 48 hours. So that should be submitted immediately to the magistrate, not beyond 48 hours. Section 166, which equivalent is 186, has remained unaltered, and the same has been reproduced in CRPC, in BNSS. Then, now we will come to another important that is section 167 CRPC, the equivalent of which is section 187 BNSS. In order to understand the changes that have been effected in 187, it is necessary for us to note what was in 167 and what is the actual change that has been effected. 167 CRPC contemplated that when a person is arrested or detained in custody and it appears that the investigation cannot be completed within 24 hours, fixed under section 58, because a person arrested has to be produced before the magistrate within 24 hours. But 24 hours is not sufficient to complete the investigation. Even though it is not completed, it is compulsory that the accused should be produced before the magistrate within 24 hours. And the officer investigating finds that there are grounds at that stage to believe that the accusation made against the accused is well founded. Under such circumstances, in order to comply with the constitutional requirement, which is found in section 58 of the BNSS, the police officer will have to produce him before the court, before the magistrate court, along with a remand application and entries in the case diary. We all know that whenever a new case is registered, police will have to open a diary, and in that diary, every day's proceedings that is conducted, every day's investigation that is made will have to be recorded minute by minute or hour by hour. So entries in the case diary will have to be submitted to the magistrate simultaneously when the accused is being produced, in order to enable the magistrate to know what investigation has been done by the police within that period of 24 hours and what more investigation is yet to be done. And in order to make the magistrate to convince himself that the investigation is still in progress and there is something more to be done. And in order to see that the accused who is produced before the court is properly attended to by the court also, judicial process, section 187 is provided. That is section 167. Section 167 subsection 2 says that whenever an accused is produced before a magistrate along with the entries in the case diary, the magistrate may order the accused to be kept in such custody as he deems fit. However, such remand shall not exceed 15 days at a time. Section 167 further says that such remand which is made from time to time shall not exceed 60 days if the offence is punishable with less than 10 years of imprisonment, and 90 days if it is punishable with 10 years and above up to death sentence. Which means after 60 days or 90 days as the case may be, the accused will be entitled for an automatic bail, which we call as a statutory bail. All these things have remained the same. There is no change at all. But the change here is when the accused is produced before the magistrate, magistrate can remand the accused to a period of 15 days. 15 days need not be remanded at a time. Either he can be remanded for a whole period of 15 days or part by part. Number one. Number two, the law hereto was, practical procedure hereto was, that if at all the police officer wants the accused to police custody, he can do so within first 15 days of remand, not later. That's how I have understood. Not for the first 15 days of remand. Supposing in the first 15 days of remand, it is not possible to secure the presence of the accused to police custody because of various reasons. Supposing the accused is hospitalized due to some illness, heart attack or whatever it is, then it may not be practicable to get the accused to his police custody at all within first 15 days. That comes in the way of investigation. Investigation cannot be completed in the absence of the presence of the accused with the investigating officer, because the nature of investigation to be done thereafter requires the presence of the accused, according to the information collected. So that will come in the way of further proper conduction of the investigation. Therefore, the changes that have been effected here is the accused can be remanded for a period of 15 days as a whole or in part within a period of 45 days. In cases of offences which are punishable with less than 10 years, and within a period of 60 days in cases of the offences punishable under with 90 days. So a remand to police custody can be obtained not within first 15 days, but within first 45 days or 60 days as the case may be. This is, according to me, an important change that has been made in section 187 BNSS, the equivalent of which is section 167 of the CRPC. Except this, rest of the things are same. There is no other amendment or alterations or additions or deletions in this particular section. Then section 168 and 169 CRPC has also been not amended and it remains as it is. Then section 170 of the Criminal Procedure Code also has remained unaltered and unamended, except adding one proviso to subsection 1 to section 190 BNSS. 190 BNSS deals with cases to be sent to magistrate when evidence is sufficient. The equivalent provision in CRPC is section 170. Here, a proviso has been added to subsection 1 to say, provided that if the accused is not in custody, the police officer shall take security from such person for his appearance before the magistrate, and the magistrate to whom such report is forwarded shall not refuse to accept the same on the ground that the accused is not taken in custody. What does it mean? The meaning is case to be sent to the magistrate when evidence is sufficient. Supposing the police officer, after conducting investigation, comes to the conclusion that the evidence that he has collected so far is sufficient to file the final report. But accused is not in custody. So final report can be submitted before the magistrate court. But how to secure the accused before the magistrate? For that purpose, the police officer has been given power to release the accused after obtaining a security for his appearance before the magistrate whenever he receives an intimation from the magistrate court. So when such bond or security has been taken by the police officer for the presence of the accused before the magistrate cannot later refuse to receive the report on the ground that the accused has not been taken to custody. So this is, in a way, a safeguard to the person who has been accused of an offense in such matters. Then coming to section 171 and 172. There are 5 subsections and there is no change in that. 171 and 172 is equal to 191. Complainant and witnesses to be required to accompany the police officer. 192, how to maintain the case diary. There is no change in this. And 193, report to the police officer on completion of investigation. Here, there is only one mandate that is prescribed in the form of subsection 2, which has been newly added, wherein it is stated that an investigation into the cases relating to sexual offences, 64 to 68, 70 and 71 of Bharatiya Nagarik Suraksha Sanhita, and section 3 and section 4, 6 and 8, or section 10 of the POCSO Act, it shall be completed within a period of 2 months from the date on which the information was received. So a time limit has been prescribed within which the police officer will have to complete the investigation and submit the final report to the magistrate. This is a new addition that has been made to section 193 BNSS. That is equivalent to section 173. Yes. There is one more important change that has been brought here. What is that change? Under CRPC, subsection 7, even after submission of a charge sheet, the police officer could continue with the further investigation and submit a report, a supplemental charge sheet before the magistrate court. 1 second, please. Yes, subsection 8 of CRPC. Section 173. Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under subsection 2 has been forwarded to the magistrate, and whereupon such investigation, the officer in charge of the police station obtains further evidence, either oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed by the state government, and in such case, in such a situation, as far as applicable, as far as subsection 2 to subsection 6 apply in relation to such report or reports as they apply in relation to report forwarded under subsection 2. What does it mean? Charge sheet has been submitted before the court. Even after submission of the charge sheet, further investigation could be done. And if during further investigation some more evidence is collected, that can be submitted before the court, before the magistrate court, in the same manner as the report was submitted. And that was the power given to the police officer. There is no time limit prescribed. So further investigation could be conducted at any point of time, till any point of time, even after submission of the charge sheet. So even if the case is at the charge sheet, that even if the case is at the fag end of the trial, if a further investigation evidence is produced, if the investigation collected through further investigation is produced, then also it should be taken into consideration by the court. That appears to be the way in which the things were happening so far as the subsection 8 of section 173. Now, under the relevant, equivalent provision, that is section 193 BNSS, a change has been brought by way of proviso to subsection 9. Subsection 9 is nothing but a replica of subsection 8 of section 173, which I have just now read, which enables a police officer to further investigate even after submission of the charge sheet. But a proviso that has been added says that, provided that further investigation during the trial may be conducted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. So now the time limit is prescribed. If at all the police officer wants to conduct further investigation, he can do so. He can do so and collect further evidence and submit the same before the magistrate within a period of 90 days. Or if the police officer is able to convince the court that there is a need for further extension of time because of the nature and gravity of the offense, or because of further new things which have come to light, etc., then the magistrate, if satisfied, may extend further time, and within that extended time, the further investigation report will have to be submitted. So this, according to me, is another important amendment that has been brought in the statute book, that is in the form of proviso to subsection 9 of section 193. Then section 194 BNSS, which is equivalent to section 174 of the CRPC. This is with regard to police to inquire and report on suicide. That is preparation of inquest, as we commonly call. Here, in CRPC, there was no time limit prescribed within which the report will have to be submitted to the magistrate. After conducting an inquest, there was no time limit prescribed within which the report will have to be submitted to the magistrate. Now, under BNSS, by adding subsection 2 to subsection 1 of section 194, subsection 1 of section 194 is equivalent to subsection 1 of section 174. There is no change. But subsection 2 has been added to say, the report shall be signed by such police officer and other persons, or by so many of them as concur therein, and shall be forwarded to the district magistrate or subdivisional magistrate within 24 hours. So police cannot retain that report with them. It should be immediately sent to the district magistrate or subdivisional magistrate within 24 4 hours. And of course, power to summon the persons for the purpose of inquest. The same provision with regard to the issuance of summons under section 160 CRPC, that is, a person under the age of 15 years or above the age of 60 years, or a person who is mentally or physically disabled, or a person who is suffering from acute illness cannot be summoned. Instead, the police officer should go to the place where they are and record their statement. However, if they are on their own willing to come to the police station or to the spot, they can do it. This is another amendment that has been brought to section 195 of BNSS, which deals with power to summon. That is equivalent to section 175 of the CRPC. Yes. Rest of the sections in this chapter have remained unchanged. Now moving on to chapter 14. Jurisdiction of criminal courts in inquiries and trial. What, madam? You want me to stop or what?
Nothing like that, sir.
Nothing like that. Good. Jurisdiction of criminal courts in inquiries and trial. Chapter 14. Section 177 to 189 of the CRPC, the equivalent of which is from section 197 to section 209 of BNSS. Here, on the aspect of jurisdiction of the criminal courts in inquiries and trial, there is one significant addition made in the form of section 202, particularly in view of the electronic and digital era. We receive electronic message from some place, maybe from Delhi, or maybe from Kashmir, or maybe from any other remote place. I am in Bangalore. I receive an electronic message, and I will be cheated. Now the question is, which is the jurisdictional police to whom I should approach? And which is the court which can inquire into and try? These questions would naturally emerge. In order to answer these questions, section 202 BNSS, a section has been added newly in the form of section 202, which reads as under: offences committed by means of electronic communication, letters, etc. Any offence which includes cheating may, if the deception is practiced by means of electronic communication or letters or telecommunications, such electronic communication messages be inquired into or tried by any court within whose jurisdiction such electronic telecommunication or letters or messages were sent or were received, and any offense of cheating and dishonestly including inducing the delivery of property may be inquired into or tried by a court within whose local jurisdiction the property was delivered by the person deceived, or was deceived by the accused person. So this is a very significant, a new addition that has been made in this chapter 14, which takes care of the offenses committed through electronic mode, and also the offenses of cheating, and all those things will be taken care of here. So this is another important section that has been brought out, that has been introduced in chapter 14 of the BNSS, which deals with jurisdiction of the criminal courts in inquiries and trial. Except that the rest of the sections have remained unamended and there is no change. Gautam sir? Hello? Shall I continue or shall I stop?
So up to you, sir.
Up to me. Okay, thank you. Now we will move on to chapter 15. Conditions requisite for initiation of proceedings. This is a very important chapter. This is from section 190 to 199 of the CRPC, the equivalent of which is from section 210 to section 222 BNSS. This is very important section because it is this chapter which deals with power of a magistrate to take cognizance. Taking cognizance of an offence means a judicial application of mind by the magistrate to the materials placed before him in order to come to the conclusion whether an offence as alleged in the material has been committed and whether prima facie accused is shown to be the person who is involved in the commission of the crime, and finally whether the case has to be registered against the accused and summons will have to be issued to secure him before the court. This exercise which the magistrate does can be termed as taking cognizance. Of course, there are other legal definitions which are found in the number of judgments of the Honorable Supreme Court and Honorable High Court of Karnataka and also various other high courts of the country. But the sum and substance of this can be summarized like this. So it's a judicial application of mind to the materials which are available on record, supposing the police files a charge sheet. So the magistrate will have to peruse the charge sheet, peruse all the documents produced along with the charge sheet, and including the statements recorded by the police, the statements of the witnesses recorded by the police, and form an opinion, a judicially form an opinion that an offence alleged in the charge sheet committed, and that there is a prima facie, there is an involvement of the accused in the commission of the offence and which requires to be tried. So that process of exercise in a simple way can be called as an act of taking cognizance. Now, I'm not talking about any of the judgments of the Supreme Court or High Court because if we start taking it, it will take much time. There are a number of judgments on this particular point. If an occasion arises on a future day, we will discuss about it separately. Now, section 190 of the CRPC, equivalent of which is section 210 of the BNSS, deals with cognizance of offences by magistrates. What does it say? Subsection 1 says, subject to the provisions of this chapter, very important, subject to the provisions of this chapter, that phrase is important. Any magistrate first class, or if specifically empowered, any magistrate second class, may take cognizance of the offence under any of the following three circumstances. Number 1, upon receiving a complaint of facts, including any complaint filed by a person authorized under special law, which constitutes such offence. So mere complaint of facts is not sufficient. That should disclose the commission of an offence. So if such a complaint is filed before a magistrate, he can take cognizance by applying his judicial mind. Number 1. Number 2, upon a police report submitted in any mode, including electronic mode of such facts. So the police, after conducting investigation, submits a charge sheet before the court, making XYZ as accused and narrating the facts as to how the offences mentioned therein have been committed and how there is an involvement of the accused persons in the commission of the offence. On that basis also, after applying judicially the mind, the magistrate can take cognizance. Thirdly, upon information received from any person other than a police officer, very important, other than a police officer, or upon his own knowledge that such offence has been committed. So if a magistrate gets an information from a source other than the police, or when he gets the knowledge that the offence has been committed, he can take cognizance. So subsection 1 of section 190 has to be mandatorily, very clearly understood by an advocate practicing on a civic criminal side. and by a judicial officer presiding over a criminal court, because he should know the process of taking cognizance. So if we do not understand this concept of taking cognizance properly, there is a very possibility that if there is a material defect in taking cognizance, it may be quashed at the threshold itself by the constitutional courts. Therefore, this is a very, very important aspect which has to be kept in this particular section, will have to be kept in mind. So subsection 1 empowers a judicial magistrate first class. The law itself empowers to take cognizance. And if a judicial magistrate second class has to take cognizance, he must be specifically empowered. Empowered by whom? Subsection 2 of section 210 says it is the chief judicial magistrate who could empower any judicial magistrate second class to take cognizance. So this is so far as section 190 is concerned. There is no change. It remained as it is. But I am telling all these things because for the benefit of the freshers or young advocates. Then section 211, that is equal to section 191. What does it say? When a magistrate take cognizance of an offence under clause C of subsection 1 of section 210, the accused shall, before any evidence is taken, be informed that he is entitled to have the case inquired into or tried by another magistrate, and if the accused or any of the accused, if there be more than one, objects to the further proceeding before the magistrate taking cognizance, the case shall be transferred to the chief judicial magistrate, who can take such steps as he deems fit. What do you mean by this? When cognizance is taken under subclause C of subsection 1 of section 210, that is, when the magistrate take cognizance on getting an information from a source other than the police, or when the magistrate comes to know that an offence has been committed. So it is something like a suo motu taking cognizance by the magistrate. So when the magistrate is taking cognizance suo motu, on the basis of the information that he himself got, then practically he will be a complainant. Because it is he who come to know of the information. Nobody has complained. There is no charge sheet. But he comes to the knowledge of that particular information, so he takes cognizance. So it is as good as he himself becoming a complainant. Therefore, section 191 says, it is a case of fair trial. 191 says, look here, you have committed such and such an offense. I have taken cognizance of it on my own. Whether you want this case to be proceeded by me only, or you want this case to be transferred to any other court. That option has to be given to the accused, because that magistrate himself has taken cognizance on his own knowledge of the commission of the offense. So a person cannot be a judge in his own case. Principles of natural justice comes in the way. So therefore an option has been given to the accused. If the accused were to say, no, I don't have any objection, this court itself can proceed with the matter. I have a lot of confidence and I repose so much of confidence. I don't have objection. Then the magistrate can proceed with the matter. Or if the accused were to object, no, let this case be transferred to some other court, then the magistrate will have to transfer that case to the chief judicial magistrate, and chief judicial magistrate will make over the case to some other magistrate within the jurisdiction. This is what section 201 says. 202. When the chief judicial magistrate take cognizance of an offence, he can make over that case to any other magistrate. That is 202. 203, equivalent to section 193. This is a very, very important section for this reason. We all know that Sessions Court cannot try a case which is exclusively triable by a Sessions Court unless it is committed by the magistrate. So a case which is triable exclusively by the Sessions Court cannot be taken to the Sessions Court directly straight away. It has to be till the case is committed by the magistrate to the Sessions Court will have no power to take cognizance. It is found in section 193 of CRPC, that is section 213. What does it say? It says, except as otherwise expressly provided by this Sanhita, that is code. Same section there in CRPC also, and so also here. In this behalf by this, in this Sanhita, or by any other law for the time being in force, no court of sessions shall take cognizance of any offence as the court of original jurisdiction. So a sessions court cannot take cognizance of an offence as a court of original jurisdiction unless the case is committed. So the committal order will have to be passed by the magistrate. And magistrate must direct the accused to appear before the sessions court on the receipt of intimation from that court as contemplated under section 209 of the Civil Criminal Procedure Code and equivalent provision in BNSS. And the records should be transferred to this, submitted to the Honorable Sessions Court. Then only the Honorable Sessions Court can take that case on record and proceed with the matter. This is what section 193 says. And so far as other sections in this chapter is concerned, there is no much amendment or alterations made. Just 1 minute. Yes, there is one important amendment that has been brought to section 197 CRPC, which is equivalent to section 218 CRPC. That deals with sanction to prosecute. When an offence is said to have been committed by a public servant in discharge of his official duty, no cognizance can be taken by the court against him unless there is a proper sanction issued by the competent authority. Who is the competent authority has been explained in that section itself. So there must be a sanction accorded by the competent permitting his prosecution before the court. It is only on such sanction being issued the magistrate court can take cognizance. I am not going to discuss about that in detail. The only limited aspect which I wanted to dwell upon is, in CRPC, there was no time limit prescribed, within which the sanctioning authority will have to exercise his power and peruse the paper and pass an administrative order whether he accords a sanction or he doesn't. Pass an order whether he wants to accord sanction or not to accord sanction. There was no time limit prescribed. As a result, the sanctioning authority could take any amount of time, any length of time for according sanction. In order to curb such a situation, perhaps in the Bharatiya Nagarik Sanhita, an amendment has been brought. That amendment is in the form of subsection 1 of section 218, wherein the time limit for according sanction has been prescribed. There it is stated, provided further that such government that is sanctioning authority shall take a decision within a period of 120 days, 4 months, 120 days from the date of the request for sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded. So, the sanctioning authority, that is the government, has got only 120 days time from the date on which the requisition is made to consider and pass an order either according sanction or not according sanction. And if it doesn't do so, after the expiry of 120 days, it is deemed to have been sanctioned. This is the one important amendment that has taken place in that is found in BNSS in the form of section 218, subsection 1, prosecution of judges and public servants. So, except this, there is no major amendment in this particular chapter. And there is one addition to subsection 1 of section 198 CRPC, that is section 219, That is prosecution for offences against marriage. So that is all about chapter 15. Now we have to move on to section chapter 16. That is complaints to magistrate. I think we can stop at this stage.
Yes, sir.
Thank you
Next
very
chapter
much.
can be taken up tomorrow. Sankirtana?
Yes, sir.
Yeah, Q&A.
Yes. Thank you, retired Honorable Justice Venkata Sudarshan, sir, for discussing the nuances of the newly implemented law. Now the forum is open for the question answer session. Requesting all the participants to send across your questions in the chat box. I request Mr. Mallikarjun, sir, to pose the questions before the speaker.
Very good evening, sir. Sir, today
Fine,
we
good
have
evening.
one question by one Mr. Anita. Yes, Miss Anita. Sir, the question is that could you please elaborate on the concept of taking cognizance?
Please.
Since the word cognizance not be defined in the code of the Sanhita, probably they have corrupted this issue. Could you please elaborate the concept?
Sorry. I'm not able to. The words are breaking now. I'm not able
Yes,
to understand.
all right, sir. I just repeat it. There is one
Okay.
query from the student by Anita saying that could you please elaborate the concept of taking cognizance?
Yes. It can be, the word taking cognizance, according to me, can be examined from two angles. One from the angle on the basis of a police report, and another from the angle on the basis of a private complaint. Taking cognizance means accepting the case of the police filed in the form of a charge sheet, prima facie, and to proceed against the accused. For the purpose of taking for the purpose of taking cognizance, the magistrate has got to do some exercise. What is that exercise is? We use the word a judicial application of mind. That means, let us say, for example, a charge sheet is filed. I'm talking about IPC because those sections are very easily available to us, numbers, than BNS. So let us say, for example, a charge sheet is filed for an offence under section 326 IPC, causing grievous hurt. But whereas on perusal of the charge sheet and other records, including medical report, we find that the offence committed is only under section 324 because as per the medical report, it is only a simple injury. Though the police have filed a charge sheet for section 326, the magistrate on judicial application of mind to the records which is available there, he can take cognizance for the offence under section 324 and issue summons to the accused only for the offence under section 324, frame the charge for the offence under section 320. That means, to put it in a nutshell, taking cognizance means a judicial application of mind by the magistrate to the materials which are available on record. It could be a charge sheet, it could be a complaint, it could be whatever it is. A judicial application of mind. So, magistrate will have to examine the paper judicially. That is applying all the legal principles to find out whether the offence alleged therein has been committed at all. Number one. Supposing a private complaint is filed. On perusal of the complaint, filed before the magistrate under section 200, there is no averment with regard to the commission of an offence at all. Then how can he take cognizance? So therefore, taking cognizance means a judicial application of mind to the materials which are available to satisfy himself two things. Number one, offence has been committed. Number two, there are materials prima facie to show the involvement of the accused in the commission of the offence. If these two things are satisfied, the magistrate can have the case registered and issue summons or warrant to the accused in order to secure his presence before the court. In a simple manner, I can give this much of explanation. If you want a very detailed manner, it can be explained even for hours together, as Mr. Mallikarjun knows.
Very true, sir. Sir, and we have one more question by Mr. Mansoor. Does this BNSS has given any opportunity for the police to seek for a police custody beyond 15 days after elapse of first 40 days and 60 days?
No. After the lapse of first 45 days and 60 days, there cannot be police custody at all. There can only be a judicial custody up to 60 days and 90 days.
So even the present BNS also, the police custody remains to the maximum 15 days.
15 days within 45 days. 15 days within 60 days.
Yes, sir.
Earlier it was not like that. Earlier it was 15 days in the first 15 days of remand only.
Yes, sir.
Once first 15 days of remand expired means the police could not have asked for a police custody at all. That was coming in the way of investigation. Therefore, the now law says either remand to such custody as the magistrate deems fit for 15 days period as a whole or in part. The wording is used there. 15 days as in whole or in part. ಮೊನ್ನೆ ಯಾವುದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಆಯ್ತಲ್ಲ, ಕಸ್ಟಡಿಗೆ ತಗೊಂಡು 7 ದಿವಸ ಕಸ್ಟಡಿಗೆ ತಗೊಂಡ್ರು, ಆಮೇಲೆ ತಿರುಗಿ ಕೋರ್ಟ್ ಬಂದು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು, ಸ್ವಾಮಿ ನಮಗೆ ಕಸ್ಟಡಿ ಬೇಡ ಜೇಸಿಗೆ ತಗೊಳ್ಳಿ ಅಂದ್ರು, ಜೇಸಿಗೆ ಕೊಟ್ರು. ಅವ್ರ 7 ದಿವಸದಲ್ಲಿ ಮಾಡಿರೋ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನೋಡ್ಕೊಂಡು ಬಂದು 3 ದಿವಸ ಆದ್ಮೇಲೆ ತಿರುಗಿ ಪೊಲೀಸ್ ಕಸ್ಟಡಿಗೆ ತಗೊಂಡ್ರು. We want the accused again for police custody ತಗೊಂಡ್ರು. So that was all done within first 15 days. Yes. Next, any other question?
Yes, sir. Right, sir. These are only 2 questions. Thank you, sir. Now I request Sankirtana.
Thank you, sir. Now I would like to conclude this session. We thank our esteemed speaker, Honorable Justice Venkata Sudarshan, sir, for spending his precious time enlightening us about the new procedural law. We are very grateful to have you, sir, as our esteemed speaker for the lecture series. Thank you very much.
Thank you. Thank you very much.
Tomorrow will be final day.
Yes, sir.
Yes. Yeah.
This academic initiative is a 4-day continuous lecture series, and the lecture series began on Tuesday, and it will continue tomorrow as well. Requesting all of you to join us tomorrow, which is the last day, to expand our knowledge about this vast topic. We certainly hope that this lecture series will help you get a better understanding of the nascent law. We hope to see you again tomorrow. Thank you for attending today's session.
Thank you.
Thank you. Thank you very much, sir.
Thank you, sir. Thank you. Good night.
Good night.